All right, all right. Well, good afternoon, everyone. I know there are people who are still trickling in a little, but my name is Regina Brown Wilson. I'm the Executive Director of California Black Media, and I'm so pleased to come and bring welcome and greetings. Today's Lunch and Learn, Unpacking Public Records in California. Today's session is presented by so many great organizations in journalism. California Black Media, well, which is who I represent, Ethnic Media Services. I know I saw Julian Doe and Sandy Close on the call, Bay City News, the Northern California chapter of Society of Professional Journalists, the Sacramento Press Club, and the First Amendment Coalition. I just want to thank you all for taking the time out of your day to learn how to make sure that we're unlocking public notices, that we're gaining access so that we can create the best journalism possible, that you have access to the records that you need to make sure that you're shedding light on things that impact the community. And so with that said, I will turn it back over to Ginny LaRoe, who will be giving you some housekeeping and any other announcements. So thank you so much, FAC, for helping organize this today.
Absolutely. Thank you, Regina. Thank you for being a great partner and inviting publications all over the state. I'm Ginny LaRoe. I am the Advocacy Director with the First Amendment Coalition, your friendly neighborhood nonprofit fighting for your right to know press rights all over California and beyond. Quick housekeeping, this is being recorded. We have closed captioning option turned on. We have a hard stop in 60 minutes, and we have a lot to get to. So let me just say thank you to the Society of Professional Journalists Foundation for supporting our educational work in the community. And thank you to all of you for making time. I see people who are veteran investigative reporters who could be giving a masterclass. So I hope you get something out of this today. And for those of you I recognize from college journalism programs, welcome. I hope you too get something out of this today. We're so glad you made time. Okay, so let me just say today's goals are to learn about the California Public Records Act. Not FOIA, not court access, I'm sorry. We'll do that too. Here's strategies for overcoming barriers to access. Get reporting ideas from an award-winning journalist, and learn about free open government resources available to you. If you're just tuning in, we would like you to use the chat to ask clarifying questions as we go. We'll pause periodically. And we'll also try to save time for the end. And we'll also share all of our contact information for direct follow-up one-on-one in a private setting. So the last announcement before I introduce you to everyone joining me today is that this is designed for journalists, but journalism and open government doesn't happen in a vacuum. And I also just want to welcome people who received the invitation, who work in government, public relations, do legislative advocacy. I saw a lot of interest, and welcome to you also. So for the journalists, that means some of your sources might be tuning in today, and we hope this knowledge sharing is helpful for everyone. So your presenters today, I'll be pitching in, and I was a newspaper reporter and editor in 5 states, and now have the honor of doing this open government and press rights work at the First Amendment Coalition. And an expert many of you already know, David Loy, our legal director here at the First Amendment Coalition, a veteran open government and First Amendment lawyer who's previously worked at the ACLU of San Diego and Imperial Counties and in criminal defense, among other things. And Omar Rashad, government accountability reporter for Fresnoland, who I met when he was a college journalist. We've been collaborating on open government training for folks, and he has stories, real world examples spanning from his college days to internships to reporting now for Fresnoland that we hope you will find useful no matter what your beat is or experience level. And I just want to give a shout out to additional FAC colleagues, our legal fellows. These are recent law school graduates who contributed to this presentation, Kristen Policarpio and Annie Capetta. Okay, with that, let me turn it over to David Loy to take us away. David.
Thank you, Ginny and Regina and everyone. Really appreciate the opportunity to be here with you. I always like to ground this kind of conversation in the fact that in California, the right of access to public records and public meetings is baked into our state constitution. What you see before you is part of the text of Article 1, Section 3B of the California Constitution. This was added by Proposition 59 in 2004, with overwhelming approval by the people. And transparency is a constitutional right in California. Obviously, the details matter. You don't get unlimited access to everything, but it's very important to understand this is not, a favor that the government is doing you by giving you records. It is your constitutional right. Now, as Jenny alluded a minute ago, there are many different open records laws, including but not limited to the California Public Records Act, which is the primary focus of our talk today. But just to kind of do a quick check-in, we're going to do a short pop quiz so people get oriented into which kinds of laws apply to what kind of records. So question 1, you are investigating the Federal Department of Homeland Security's use of an AI tool to surveil individuals crossing the border. You'd like to see DHS's internal memo that analyzes the tool's level of intrusion on people's privacy. How should you request that record? And answers in the chat or in the quiz.
You knew we were going to test you all. We saw so many experienced reporters and editors here. We couldn't just let you test your knowledge. All right.
So do we have results tabulated?
Yep, so we're sharing the results now with everybody. If we want to explain the answer for them.
Absolutely. Do I see the results too? I don't see them.
Oh, apologies. We have 98% of guests saying FOIA requests to DHS.
And 98% of you are correct. Federal agencies are governed by the Federal Freedom of Information Act. Similar concept, just different law, different agencies.
Do the next one, if possible.
Question 2, you'd like to access search warrant materials after learning that San Francisco Police Department officers served a search warrant on Google seeking data it maintains. What's the best way to access these records? We're talking about the materials that were given to the judge to justify the warrant, allegedly.
Criminal defense attorney editorial comment. And our friends, and our friends at Bloomberg who are tuning in, I see reporters, editors at Bloomberg, and this is ripped from one of your headlines. So we'll share this link. Okay.
Yeah. So options are FOIA request to San Francisco PD, CPRA request to Google, search court records, or Legislative Open Records Act request to the police department. So. And
so we're sharing the correct answers now.
And the correct answer is to search court records because materials given to a judge to persuade the judge to take action are by definition court records. Hypothetically, the police department might have kept its own copies, so it wouldn't be wrong to submit a CPRA request to the police department. The police department might not give them to you. That's a different question we'll address later. But among the best answer among these four is to go search the court records. Because courts technically are not subject to the CPRA in California. They have their own separate access rules. So question 3, elevators are routinely malfunctioning at the California legislative offices in Sacramento. You'd like to find out what's going on. You think the California Department of General Services, DGS, has relevant records. So do you submit a FOIA request to DGS, a CPRA request to DGS? Do you search court records? Do you submit a Legislative Open Records Act request to DGS? Again, the Department of General Services.
All right, we're sharing results now, and it looks like 79% said CPRA request to DGS.
And that is the correct answer because DGS is a state executive branch agency subject to the California Public Records Act. If you wanted records from the legislature as such, you might go through the Legislative Open Records Act. But if you want DGS records, that's a CPRA.
Our next one. And thank you to my colleague Suzanne Ito sharing. We pulled these from your published reporting. These are ripped from your work. So we're sharing some examples of where we got these ideas.
I think those are all of our quiz questions.
Yeah, so the quiz is designed to illuminate, the fact that different laws apply to different buckets of agencies. So for the California legislature, it is technically not covered by the California Public Records Act. It's governed by the Legislative Open Records Act. Different law, similar concepts, different at the margins. Federal agencies, again, governed by the Federal Freedom of Information Act. California and federal courts are not governed by either the CPRA or FOIA, although court records are or should be open to the public in most circumstances. Get them online if that's available or in person from the clerk's office. I know there's a lot of logistical details dealing with courts, but in principle, they should be available. The California Public Records Act, the focus of our talk today, applies to state and local government agencies in California. For example, a city, a county, a school district, any other kind of special district, or all the multitude of state agencies, not counting the legislature. What qualifies as a public record? Well, basically anything written down in any way of recording information in any way, shape, or form, hard copy, electronic, digital, you name it. Is it related to the conduct of public business? Is it prepared, used, owned, or retained by the state or local agency? It does include records about public business that are housed on personal devices or accounts. The mayor of San Jose, for example, is notorious for running the city through Gmail and text, not official city accounts. But a public record is not anything that's purely personal, even if it's on a government server. So my personal contacts, my grocery list, my purely social, dinner invitation would not qualify as a public record. Key facts about the PRA: anybody can submit a PRA request in California. You don't have to give a reason. It is your inalienable right as a member of the public. Records must be disclosed unless specifically exempt from disclosure by a particular law. Agencies cannot discriminate between requesters. They cannot discriminate based on the purpose of the request. We recommend submitting requests in writing in most circumstances. It may not always be necessary if you have a good relationship and you get records easily. It's always good, though, if you have any likelihood you might need to follow up on that or contest it, to have a clear record of what you requested and what you were given. Agencies must make some kind of determination about the request within 10 days, sometimes an extra 14 for unusual circumstances. Determination here means we got your request, we either have records are responsive or we don't, or they're exempt from disclosure or they're not, and here's why. That does not mean they have to actually give you the records within 10 to 14 days or 10 plus 14 days. That means they have to at least get back to you and tell you they're going to give them or not. The only deadline right now in the PRA is that disclosure must be, quote, prompt, unquote. That is very much in the eye of the beholder. What you or I or others seeking records might think is prompt may be very different from what a judge might say is prompt or an agency might say is prompt in a given circumstance, depending on the volume of records at issue, how much time it takes to find the records, review them, redact them, prepare them, and so on. Fundamentally, though, the agency in California, public agencies have a duty to help you with requests, help you clarify the scope, help you locate records responsive to the spirit of the request. It's supposed to be an interactive, iterative process. And if they don't, feel free to insist on your right to seek help with the request. I often will put that language in the request itself just as a reminder. I presume officials know the law, but it never hurts to be upfront. This is your duty to help me, please do. There can be some fees for obtaining copies of public records. Generally, under the PRA, agencies can only charge direct cost of duplication, or a statutory fee if applicable. Statutory fee means some statute outside the PRA that is specialized to a given circumstance or agency that specifically says the amount to be charged or tells that agency that it can establish a fee schedule. Classic example is that there's a section of the vehicle code allows DMV to set its own rates for its own records. It's an explicit statutory authorization. But typically what you'll run, those are fairly specialized. What you'll typically run into is just direct cost of duplication, or certain, down at the bottom, certain charges of programming computer services to extract data. You know, like say the agency has raw data and has to process that into a spreadsheet that doesn't already exist, even though the raw data are in the agency's control, the time it takes to just run that spreadsheet, for example. One good workaround is that the PRA allows for both the right to inspect and copy records, and you have the right to inspect them free of charge, typically. So if you want to say, I'd like to inspect a bucket of records and I only want to order copies of the ones I need, or you can even take your own pictures or make your own copies of the records, as long as you're not damaging or affecting the records. Generally speaking, of the PRA, the Cal Supreme Court has held that agencies may not charge for the time that their staff spend to find the records, go through them, decide what's exempt or not, and then redact or delete the provisions that are exempt. If they do assess fees, they need to tell you why, pretty much. You know, they can't just sort of make stuff up. There has to be a good legal reason they should tell you. And you can always ask for the fees to be waived. Agencies may not always be obligated to charge the fees, even if they do. So feel free to ask for a waiver in the public interest if need be. So I know a key topic of many journalist reporting is, you know, government accountability, misconduct or disciplinary actions against public employees. And I want to talk about the majority of public employees here. I'm going to bracket law enforcement, talk about that separately, because there's different legal rules about disclosure of records about law enforcement officers' misconduct. But generally, for all public employees except peace and corrections officers or peace and custodial officers, the rule of thumb is if there's any form of discipline imposed against a public employee, however minor, even a private letter of reprimand, that must be disclosed to the public, full stop, right? There's been an investigation, they found out, determined that the misconduct occurred and issued some kind of discipline, the public is entitled to a copy of that. Apart from that, even if there's no actual discipline imposed or no finding that the misconduct actually occurred, if there was reasonable cause to believe that the complaint of misconduct was well-founded, and it's a substantial issue, maybe not punching in a minute late, but, you know, a substantial issue of, let's say, harassment or embezzlement or fraud, and there's good reason to believe it could have occurred, even if it ultimately was not substantiated, again, the public is entitled to those records. If it's trivial, groundless, probably won't get it. However, the rules are different for high-ranking officials. And the cases talk about superintendent of a school district. I would argue any high agency executive, be it the superintendent, the CEO, the city manager, the chief operating officer, or maybe their number two. If there's allegations of misconduct against the high-ranking officials, you're supposed to get everything, even if they're completely exonerated, even if there's, you know, it's found to be completely untrue. The courts have said that the public has a compelling right to know how investigations of high-level officials have been handled, and were they to monitor, were they given any kind of special treatment or favoritism? Even if it turns out they weren't, the public has a right to know. So what about police misconduct and use of force records? Key point here, the law is different, and I will not get into why that is. There's lots of historical reasons why peace officers get special treatment for disclosure of records, and I will not get into whether that's a good or a bad thing. I'll just say this is what the law is. Historically, and still true in many cases, it's very, very difficult, if not impossible, to get records about law enforcement. Most law enforcement personnel and investigatory records still remain secret and off limits to public disclosure. So you cannot generally get, say, an officer's entire personnel file. You cannot generally get complaints or findings of misconduct against officers. You cannot generally get the police's own case files, their incident reports, their investigation reports. maybe some limited details extracted from them, but you just cannot get the records themselves. Now, exceptions to that as a result of recent laws, SB 1421, AB 748, SB 16. These were sea changes in California because historically California was almost a complete black hole of police transparency. Now, you know, we have more light. It's not unlimited. It's not as much light and disclosure as some other jurisdictions, but it's not nothing, and it's not insignificant. So as to claims of misconduct against peace or custodial officers, these laws require disclosure if there has been a sustained finding. Sustained finding is a key term here. It means that the department determined that it occurred, that it in fact occurred, and the officer has exhausted, or at least had the opportunity to exhaust all opportunities to appeal that. So sustained finding of sexual assault against a member of the public, dishonesty in the line of duty, excessive force, failure to intervene against another officer using clearly excessive force, prejudice or discrimination on the job, an unlawful arrest or search. And the records cannot be withheld simply because the officer is resigned pending the investigation. Now, that's misconduct records. There's another two buckets of records that must be disclosed, even if, legally speaking, the officer acted entirely appropriately, even if there was no discipline imposed, or even if there was no internal affairs investigation at all. Anytime an officer fires their gun at a person, or anytime an officer uses force resulting in death or great bodily injury, those records must be disclosed, full stop. Now, they're subject to certain delays and so on, but bottom line, they have to be disclosed, even if in the eyes of the law or department policy that use of force or shooting was entirely proper and justified. Great question in the chat from Dave about high-level officials on police chiefs and command staff. Really good point here. Police chiefs in police departments, when they're appointed, they are typically considered still peace officers. Elected sheriffs, however, because they're elected by the people as a whole, are not considered employees of a law enforcement agency, and the elected sheriff themselves, him or herself, is not covered by these laws. That's may or may not make a whole lot of difference, but it's a good point to know. When you're within the bucket of SB 1421, SB 16 records, okay, this is the kind of stuff you're entitled to get, which is virtually everything about that incident, all the investigation, all the photo, audio, and video, all the interviews, the autopsy reports, everything. Even if there was no discipline imposed, you should get all the records.
David, let me just pipe into, I know we're going very fast on these concepts. We really wanted to make a broad overview here. Reach out if you would like a deep dive session into the police transparency laws, such as they are in California. We do a custom session on that. Just reach out. You all have my email.
Yeah, great point. We do custom session on that. We also have a really good police transparency handbook on our website. Maybe someone can put that in the chat. It's a great resource. We have other resources on our website as well, but let me say one thing real quick. I mentioned AB 748. That is a statute specialized to critical incident audio and video recordings, basically body cam videos of, again, police shootings or use of force resulting in death or great bodily injury. Those videos are also covered by SB 1421, but AB 748 gives you an independent right to them. And there's some differences at the margin about how long they can hold on to those videos and what are the excuses for withholding. I won't get into the weeds of that, but just know, and this is all laid out in our police transparency handbook, AB 748 is specialized to audio and video of the so-called critical incidents, again, without regard to whether there was any misconduct. You can get those videos and audios under both 1421 and 748. But again, there can be differences in the timing. So again, those nuances are great for our hotline, also laid out somewhat in our police transparency handbook.
Thank you. And we are dropping those links for everyone. Okay, let's go into the most frustrating. I feel everyone on this call. I feel you going, like, the delays and the denials and the rigmarole is just exhausting. We hope to give you here quickly talking about exemptions, which there are too many to discuss, some maybe additional strategy insights for
yeah. I mean, Delays are chronic, and if you're experiencing obstruction delay, I don't know if it makes you feel any better, but you're not alone. Misery loves company, and it's a chronic problem up and down the state because the PRA doesn't have a hard deadline for producing records. I mean, as of yet. But anyway, the general principle, as I said before, all public records are presumed to be open to the public, disclosed to the public, unless the agency can justify withholding them by pointing to a specific exemption. And we'll discuss some of the more common exemptions you might run into, but there's some overarching principles that apply to all withholdings, all redactions. So first is the exemptions must be narrowly construed, right? If there's any doubt, err on the side of disclosure. The burden is always on the government to assert and prove why the exemption applies. They control the records. They have to claim the exemption, and if they were challenged in court, they would have to prove why it applies. Many exemptions are discretionary, not mandatory, in the sense that an agency is allowed to assert them, and as a matter of course, many often do, but they're not always required to assert them. There are exceptions to that. For example, the statutes on police personnel records, those that are not open to the public under SB 14, 21, and 16. If police personnel records are not covered by the new laws, an agency is actually mandated to withhold those and can get sued by an officer or officers union if they release or disclose personnel records that are not open to the public under SB 14, 21, and 16. Key point, just general point of the PRA, typically an agency may not withhold an entire record just because part of it is exempt. If there's any way to redact or delete the exempt portions, they have to give you the part that is open to the public, if that makes sense. So here are some of the most common exemptions, and there are dozens literally of potential exemptions. Some are highly niche and specialized, but these are ones that I think we most commonly see, and you may most commonly see. So one big problem in California law, from my standpoint, is this idea that all police investigatory records are exempt from disclosure forever. Any investigation of any crime, no matter how major or petty, those records are essentially off limits, again, outside of 1421 and SB 16. They may have to disclose certain, nuggets of information from those records, but you basically just can't get police reports in California, with rare exceptions. Agencies can also what's called so-called preliminary drafts and deliberative process. This is very much in the eye of the beholder. Sometimes this is abused, in my opinion, but in essence, at its core, I understand the concept, which is whether in writing or in person, agencies need to have the room to discuss things candidly internally, to brainstorm, to share ideas. Attorney-client privilege. This is, yes, public agencies have lawyers and they're entitled to the same attorney-client privilege as a private person or company, limited to confidential communications for the purpose of obtaining or receiving confidential legal advice. So not all legal documents, that which is filed in court obviously is open to the public. A contract negotiated between lawyers, a public agency lawyer and outside lawyers, once that contract is done, that's a public document. But the core of attorney-client privilege is, the confidential legal advice between, let's say, the city council and the city attorney. If an agency is specifically preparing records to use in litigation, sometimes those can be exempt. That doesn't mean every record that might be relevant to a lawsuit. Let's say there's a wrongful termination case, and let's say the performance review of that employee, is a key piece of evidence in that lawsuit. That performance review was not created for the purpose of litigation. It was just ordinary performance review. It might be exempt for some other reason, but it's not exempt under the litigation exception. If, on the other hand, agency staff are preparing a list of all the things that employee did wrong and giving it to the agency's lawyer for a purpose of the lawsuit, that might be exempt under this exception. Does that make sense? There's catch-all exemptions for just general right to privacy, undue burden. These are essentially balancing tests and sliding scales. Balance the public's right to know against the privacy interest. Balance the burden on the agency versus the importance of the records. It's very fact-specific, fact-intensive, case-specific. Again, great questions for our hotline if you get those, in practice. Here are some examples of common things that we've seen agencies do that come across our hotline that I think are very problematic, and I think you should push back on. And this is not by any means an exclusive list. My bottom line is if something feels wrong, call our hotline or write to our hotline and ask us, because if it feels wrong, it might well be wrong. Doesn't mean it always is, but trust your gut. So sometimes I've seen circumstances where a disciplinary finding or a reprimand letter, but the agency lets the employee redact it. Here, you redact this before we send it out to the requester. That's a no-no. Agencies cannot allow third parties to control or veto what is disclosable. They have an independent legal obligation to disclose everything that is properly subject to disclosure. And the public employee simply doesn't have a right to veto that. They can ask, they can certainly, share their input if they wish, but at the end of the day, the employee is a third party to the request. The requester has a right to everything that's subject to disclosure. Some agencies just stonewall and they just won't give you disciplinary findings against public employees other than peace officers. It's just dead wrong. I mean, they'll wave around the idea of employee privacy. Well, I'm sorry, but the courts have already resolved that question. And, if an employee has in fact been disciplined, even a letter of reprimand, even a private letter, that the public has a right to know. I've seen situations where some agencies don't understand that settlement agreements must be disclosed, whether it's before or after litigation. If you're settling a dispute, that's a contract. Public agency contracts must be disclosed, even if they're denominated or named or labeled as confidential. Private parties, government agencies cannot bargain away the public's right to know.
David, thank you so much. I know we're going very fast. We wanted to pack a lot in here today. Hit David with any questions in the Q&A or chat, and anything that's fact specific or really you want one-on-one, reach out to us directly through the hotline. Okay, so I'm delighted to turn the mic over to Omar Rashad to talk through some of his reporting that may be useful for your newsroom or organization or in your work as an independent freelancer. As I told you, Omar is with Fresnoland, but we've been featuring some of his open government reporting since he was a college journalist. So Omar, welcome. Thank you. Please take it away. We have about 12 minutes.
Got it. Awesome. Thanks so much, Ginny, and thank you, David, for that rundown. Thanks, everyone, for joining us. So just for some background, before I was a reporter at Fresnoland, I covered higher education for about 3 years in California. I really miss that old beat just because that's where I first learned how to use California's public records law. And basically right here, we'll just be talking about some examples of, using California's public records law to obtain documents and data. So first off, let's start with the concept of just really figuring out what public agencies intersect with your beat. David mentioned a few agencies, and, I just recommend as a starting point to just take a step back and figure out, if you're covering, city and county government like I am, you've got the mayor's office, you've got a city council, you've got a county board of supervisors, you've also got, let's say, committees on, the city council and the county board of supervisors. If you're covering housing or homelessness, you've got a local housing authority, most likely. There's likely a homelessness department on the county level under the Department of Social Services. On the county level as well, there's likely a continuum of care that, has to do with figuring out how to address homelessness across the county. And essentially, once you identify those agencies that intersect with your beat, the next step is to essentially begin thinking, how do public officials communicate with each other, and how do they communicate with subordinates? Something that is worth thinking about also is what documents are created internally as part of normal course of business. Major decisions, at the city council or at the county board of supervisors, they're not made in a vacuum. There's a lot of lead up and build up to those decisions being made, whether it's, a city ordinance that makes it illegal for unhoused people to set up a tent on a sidewalk, or let's say the county board of supervisors wants to amend, the county charter in a ballot measure next election cycle. So right off the bat, especially if you're running into public officials not responding to your emails or phone calls, something worth thinking about is, are public officials texting about a matter with colleagues? Are they exchanging emails about a specific matter with colleagues? If that could be the case, maybe you hear from an off-the-record source that they received an email containing some information. Maybe that's something you could submit a public records request for. Long before a city decision is made, staffers usually produce reports that are sent to people above them, and they influence decisions. If those staff reports are not already publicly available, I'd first find out if they exist and whether or not you can maybe submit a public records request for them. Something else to keep in mind, especially if you're in local news, I would search your city and county in the California State Auditor's website. And just see what comes up. I found a lot of cases where Fresno comes up in state audits about homelessness, housing, healthcare workers, license plate readers. Those types of audits are certainly things that are perhaps like low-hanging fruit, especially if they're at least 3 or 5 years old and worth maybe following up on if, issues addressed and documents mentioned in those audits could maybe be the subject of a public records request. Another thing is public agencies enter into agreements with private companies all the time. If you want to figure out, when and how a local police department obtained, a $500,000 SWAT vehicle, that's something you could submit a PRA for to understand when that contract was signed and when that was essentially, signed through and made a deal on. One major point that I definitely want to stress, it's super important to just understand what exists in the first place, just so you know what to ask for. Excuse me, just so you know what to ask for. David said, California requires that anyone requesting information, should be helped by the agency that they're requesting information from. It doesn't also hurt to be savvy with off-the-record sourcing just to help you identify what emails are out there or what internal documents exist. All right, on the next slide, here's our first example. If you'll remember, in late 2021, early 2022, that's when Omicron caused a spike in COVID-19 across the country. That specific variant was particularly sinking its teeth across the world. And back in January 2022, I was a student at Cal Poly San Luis Obispo. My university was the only California public university to reopen its campus for in-person classes 2 days into the new year. So every other university either delayed or pushed classes remote because of the spike in COVID-19 cases. And so many students tested positive for COVID-19 at Cal Poly San Luis Obispo that the university ran out of on-campus isolation beds 2 days into the new quarter. So the quarter started on a Monday. By Wednesday, there were no more on-campus COVID-19 isolation beds. The university then actually began putting COVID positive students into local hotels since there were no on-campus beds available. I was the first to break that story in the region for the student newspaper Mustang News. And right after we broke that story, I immediately filed a PRA, because if a university is putting students in local hotels, that would have to mean they're entering into contracts, or at the very least, they have receipts of that transaction. And so I filed a PRA, and what I ended up obtaining were contracts that corroborated how in 1 month alone, January 2022, the university spent $100,000 on hotel expenses just on isolating COVID positive students. On the left, you can see a few graphs from the story I reported, and on the right, you can see a data visualization. It's a simple donut chart that disaggregates for how much money was spent on exactly which hotels. And I think this is the most basic example of just having a document state of mind. In this case, I got my hands on data and contracts, and it led to an entire story about how taxpayer dollars were used in a hasty campus reopening plan as Omicron was specking across the nation. So on the next slide, I'll be talking a little bit about sort of the first example of an equity story that I got to report. Back in 2021, I was a reporting fellow with Cal Matters, and I wanted to understand the diversity of police officers at California's 33 public universities. That, of course, consists of the 23 Cal State campuses across the state, and also the 10 UC campuses across the state. On the next slide, you can see how I sent a PRA to every single one of those 33 public university campuses. And I was essentially asking and seeking anonymized race, ethnicity data along with gender data of all sworn police officers. Most of the campuses denied my records request. Kind of sad. But through the course of reporting, I found out that there's actually a state agency in California that collects demographic information of all sworn police officers in the state of California. So I just sent a PRA to them. I asked the same thing that I asked the 33 campuses, race and gender of all sworn police officers at these 33 specific agencies, and I just listed them out. This state agency, they're called Post. They also denied my PRA as well. They said that fulfilling the request would violate the personal privacy of police officers. And I think this is one of the different examples that David brought up about, some roadblocks that you can maybe hit when you're requesting documents or data. This is really common, personal privacy agencies cannot, release personally identifiable information. But that's also exactly why I asked in the first place for the data to be anonymized. So yes, I want the race and gender of police officers, but I don't want that to be connected to their name or their badge number. I'm trying to understand on an aggregate level what that diversity looks like across departments. And so after Post denied my PRA, I went to the First Amendment Coalition to get some help. And one of the lawyers there was nice enough to chat with me and share some general thoughts and advice. He also pointed to me current case law that could really help make a case for why I should get the data that I'm requesting. On the next slide, I went off the advice that the lawyer gave me from the First Amendment Coalition. On the left-hand side, you can see how there's an essay of an email that I wrote in response to a rejection that I got from Post. And in it, I'm quoting case law, and I'm just making a case for why I should be able to obtain the data that I'm seeking. In 1 week, they buckled. They sent me one of the cleanest spreadsheets I've ever received from a public agency, the anonymized race and gender of hundreds of sworn police officers at California's 33 public universities. And you can see on the right-hand side of the screen, we have a screenshot of what some of that data looked like. On the next slide, you can see the story that we broke that no one else had. And one of the excerpts from the story at 32 of 33 public university campuses in California, police officers are whiter than the students they serve. And in many cases, those disparities are glaring. At Cal State Monterey Bay, for example, the student population is just over a quarter white, yet of the university's 15 police officers, 12 are white, so about 80%. And on the right-hand side of the screen, you can see, a bar chart comparing diversity. And once again, you can see a lot of campuses have a glaring disparity in terms of white police officers when most of their students are not white. On the next slide, I'm going to touch on, or actually, sorry, moved ahead a little bit there. On the next slide, I'm going to touch on one more equity story. Yes, thank you, Ginny. And I hope this isn't too dense to follow along. I know we're jumping through a lot of information here. But this next story is about the American Rescue Plan Act, also known as ARPA for short. I wrote a story looking into how and why Fresno County gave $200,000 of pandemic relief funds to a local rodeo. On the screen, we have an excerpt of the story explaining how Fresno County officials did not assess whether organizations needed pandemic relief funds before giving them thousands of dollars. We also found that county officials did not develop a metric to evaluate organizations for their equity aims. In the next slide, we have some information on why equity is so important in the context of the federal ARPA program. President Joe Biden has referred to that program as being the first opportunity in office for him to advance equity through major legislation. And he also released a 301-page report expanding on exactly how the ARPA program was supposed to support an equitable economic rebuilding out of the pandemic. And so for this story, what I ended up doing was I sent a PRA for application materials that the rodeo submitted to Fresno County in order to obtain federal relief dollars. And in it, I found something really interesting. Every organization that applied for funding needed to explain how they would promote strong, equitable growth and racial equity among impacted communities in Fresno County. And in response to that equity question, the rodeo said, 1, they don't discriminate against anyone. 2, they strive to be family friendly, and 3, they have affordable tickets. And just to reiterate, this is in response to a question about how their request for funds promoted equitable growth and racial equity amongst underserved communities. And so looking at this application that I obtained, through a California Public Records Act request, that really helped inform questions that I just went to Fresno County with when I was trying to understand why and how they awarded a rodeo $200,000 of federal relief funds. And once again, they didn't have a metric to measure equity, and they also did not compare organizations with each other to figure out whether they actually needed the money. This story was published in April this year, and later in August, the county was distributing a second round of COVID relief funds to organizations, and the rodeo applied again for funding, but they were denied. And I'd like to think our reporting, made the county think twice about giving the rodeo money. On the next slide, here's more information on, the ARPA program. And I really do think this is a story that can be localized, replicated, and you can do a much deeper dive than what I did. For starters, the federal government issued $350 billion to local governments across the country. It's extremely likely, if not guaranteed, that your local city and local county received federal relief dollars. These dollars can only be used for 4 specific instances or categories. One is to provide revenue replacement for government workers. Another is to provide premium pay to essential workers. Another is to upgrade sewer, water, broadband infrastructure. And another is to promote an equitable economic recovery from the COVID-19 pandemic. Local governments were actually required as part of this program to survey residents to understand what residents wanted federal relief dollars to be spent on. So right off the bat, you could begin by sending out a PRA for surveys that the local governments put out to residents. You could also PRA for responses to that survey to understand what residents were communicating in terms of what they wanted federal relief dollars to be spent on. And it's really common when, local governments are sending out surveys. Internally, they're likely organizing all of those responses in one file, just so that they can communicate internally on, what survey responses look like. After you've PRA'd for, the survey, responses to the survey, you could then PRA for ARPA expenditures that your city or county government has, and essentially just match up what residents say they want federal relief dollars to be spent on, whether that matches up with what was actually spent. Or what was actually used using that federal relief dollars. And at the same time, if you're going to PRA, federal relief dollars and how they were spent by local governments, that's going to yield lots of different kinds of stories. And maybe you don't do the full investigation into whether or not, local governments spent the money the way residents wanted them to. Maybe you do something as simple as what I did, just really look at one specific case of how the money was used and try to probe whether or not, what that process was behind awarding that money. On the next slide, here's some just quick takeaways. Something super integral, like I mentioned before, is just having someone on the inside. This is always going to benefit you because they're your number one shot at understanding what documents exist. Definitely use the First Amendment Coalition's legal hotline. And lastly, it can take a while for you to obtain records through a PRA. It can vary from, I've gotten PRAs back in a day. Sometimes it could take a week. A lot of times it takes a month. I have records that still haven't been turned over to me from more than a year and a half ago when I was a student at Cal Poly San Luis Obispo. But the bottom line, if you have any difficulties with, obtaining records, definitely reach out to the First Amendment Coalition. And on the next slide, if you have any questions or, are trying to figure out how to narrow down your PRA, I'm also more than happy to help. I'm also a huge proponent of just using data journalism along with public records law to really understand, how systems operate and how they create outcomes, and data is one of the best way to do that. There's a misconception you need to know some complicated coding language like Python or R in order to analyze data, and that's not at all true. I've spent all my time doing data journalism in Microsoft Excel or Google Spreadsheets. My email address is on the screen, and you can also find me on Twitter. And it could be as simple as, hey, Omar, you spoke to us in February, or I mean, not February, October. And I'd appreciate some help, and I'd be more than happy to respond. yeah, that's it for me.
Omar, we're getting private messages in the chat just saying inspired work. Thank you. So thank you for that, and always being willing to share your ideas with folks, mentor folks, pay it forward. It's so appreciated and it's so needed. We are coming to the end of the session, and we do have a hard stop today. So let me just go quickly through a couple of points here. Keep sending your questions to David Loy and the panelists. He's responding in the background. But just really quickly to underscore everything we've talked about today, really good habit is to make your request in writing, even if you started it on the phone with a source or someone. Document. Be the squeaky wheel. Put these request deadlines on your calendar. Follow up. We know it's exhausting, but it's we know this stuff is often challenging to keep track of. So give yourself every advantage by hounding the government if you need to. I'm going to just move ahead and say, we have some general tips. We're here for you to strategize if you get, a response that your request is unduly burdensome or overbroad. Doesn't mean you have to just give up. Come to us if that happens, so we can at least try to strategize with you. Let's see. Just to underscore something that we talked about with a document, if it's heavily redacted, that doesn't mean the end of the story. Here's an example from another state where records clerk just heavily redacted. I counted like 28 or 29, and I just wrote back citing what I thought was, the correct law, got a better version back. So, don't take no for an answer, like Omar said and David said. Sometimes it's helpful to do a story about the secrecy. Tell your readers why you can't answer questions that they have. We used to consider this in newsrooms a bit of inside baseball. People don't want to know about your challenges. We think often it's really helpful to tell the public that you tried to get them an answer and you couldn't. Lastly, just a couple things I wish I had known in different states when I was starting to learn a new state's public records regime. In California, like a lot of places, your request itself is a public record. So only put in there what you want your government sources or perhaps other reporters to see. These are often put on next requests or other portals where people will see what you're asking for, and use that to your advantage. See what advocacy groups and your competitors are asking. If you're lucky enough to go to conferences like IRE, they'll talk about FOIA the FOIAs. That's that same concept. So it can be a competitive concern that everyone can see what you're asking for, but it can also work to your advantage. David told you the government can't favor one requester over another. So if you see that the government has released something that like a mayor's office has released something to someone, it's in a story, use that to your advantage. To say, well, you turned me down, but I see it's out there. Okay, so we have 6 minutes left. What kind of questions, David, are you seeing that you can kind of answer while we tee up our resource offerings for everyone? Anything that you want to address live for everyone's benefit?
Yeah, absolutely. I mean, the stuff you see on the screen is stuff that I think it's subject to disclosure and can be really valuable from a reporting perspective, like employment contracts, severance agreements, particularly the latter. If someone takes a severance deal and you want to know, is it a sweetheart deal? That's a public document. Emails or texts between government employees or between government employees and outsiders about public business. That was a huge part of our case against the city of San Jose recently. Could be within an agency, between multiple agencies. Legal settlements. So every settlement agreement talked about before, that's a contract to resolve a legal dispute. What gets filed in court might just reflect case dismissed pursuant to settlement, full stop. But the terms of that settlement will be in the contract or the agreement that may not be filed with the court. So you can get that from the public agency. And of course, any official policies and manuals, training manuals, policies, procedures, et cetera. Even if they're boilerplate, sometimes you can use that to check against actual performance, right? Are they living up to their own stated policies and procedures?
Well, we have a good question, David, here. I don't know if actually, you and Legal Fellows have done this at the First Amendment Coalition. So
Yeah.
it's not just a tactic limited to journalists, but Erica writes in, how do you FOIA the FOIA? So let's do, how do you PRA the PRAs? What's your best advice?
Well, just in any PRA request, just describe the documents you want as clearly as you can. So I would like all public records requests filed between January 1 and June 1. Now that might be a huge amount. You might want to narrow it by topic. As a practical matter for agencies that use things like a next request portal, they might already be visible to the public, and you might be able to just go straight to the website without having to make a request. So always check to see what agencies are posting online, but it's no different from requesting any other documents. Just say what you want. Now, if you want a huge volume, it might take a while. But if you want like all the PRA requests on a given topic, like all PRA requests about this development proposal, this conditional use permit, building this police station, this, water treatment plant, what have you. The world's your oyster.
Right. And who here has ever requested records about your own request? Like, okay, so after I requested this, I think they were sending political emails talking about, yeah. So that's a tactic. You might have to have thin skin to see what people are saying about you. Just a real world example of the FOIAs. Here's something in California. This is a brilliant colleague I worked with at the San Francisco Chronicle, who was covering wildfires and PG&E. And so PG&E is regulated by the California Public Utilities Commission. Well, we went on to the Next Request portal. We looked at what other news organizations had been asking for about PG&E. And we thought, well, maybe if we do a narrower, more tailored request, we do it even more strategically, maybe we'll get ours responded to first because it's easier. So, I can't remember. I'm sure they were really on top of it and really fast responding and giving us our records, but just an idea for you if you have the time. Okay, let me just ask my colleague, Kristen Policarpio, just to run through really quickly what some of the resources folks can use after today.
Sure. So as we've talked about all throughout the presentation today, please utilize the legal hotline. The link is in the chat. We can drop it again, but all of your questions go directly to the legal team. We'll see it as soon as you submit it. So if you have any questions now, or you were scared to use the chat, or you think that it's a little bit bigger than something that you can drop in the chat, go ahead and send us a question on the legal hotline, and we'll answer it. Some other things for folks, even if you've been doing a lot of PRA work, or if you're a little bit new to the work, we have a CPRA handbook online. This is something available on our website that you can click through. We have frequently asked questions, so things that we've seen come across our table quite often, and other kind of just like little things that'll help you put in your PRA requests. And
also,
speaking,
I just want to say on these frequently asked questions I wrote, I want your frequently asked questions. So hit me with the thing you wish we could just break down to a quick question and answer and put it on here. We want to make this as useful to you as possible. Thank you. Go ahead, Kristen.
And speaking of things that would be helpful, if you've never done a PRA request before, or if you are feeling a little bit rusty and haven't done one in a while, we have a sample request letter on our website. You can just copy and paste the language, fill it in, be as precise in the documents that you're requesting as possible, but please feel free to use our template. That's what it's there for. And finally, those who were asking more about law enforcement and police transparency, information and background, we have an entire handbook. You can get a hard copy or you can download it on our website. And it has a lot of really goodies and things that can help as you put in your requests.
Thank you so much, Kristen. Thank you, everyone, for your great questions. I know we were going so fast. David, Loy, and Kristen, and our colleague Annie, they are three legal professionals here for you to help empower you. Reach out to us. We'll do our best within our small nonprofit bandwidth. And thank you, California Black Media, Ethnic Media Services, the Sacramento Press Club, the Society of Professional Journalists Northern California chapter, and the Foundation for generous support, Bay City News, and its Chief Kat Rowlands for helping us convene today's call. And this is the beginning of a conversation, not the end. So we will see you all online or at our next one. And we're eager for your ideas and feedback about how to make this more useful. So we will also be sending you a very short survey afterwards. Thank you so much. Thank you, Omar.